18 women contacted my attorney in the first 2 weeks after I filed the lawsuit. 18. All of them had been harassed by the same man. All of them had been paid to stay silent. All of them had signed NDAs they thought would last forever. And all of them had been waiting, some for over 20 years, for someone to speak first. The oldest case was from 1998. The youngest was from 2024. A 26-year pattern of harassment, cover-ups, and hush money. One man protected by one company through hundreds of thousands of dollars in settlements and the silence of nearly 24 women. The company had spent $2.8 million over 26 years, keeping him employed and keeping us quiet. But in January 2026, California passed a law that changed everything, and I was the first person to use it. Let me back up. Let me tell you how I got here. My name is Maya Patel. I'm 43 years old, and I'm an employment attorney specializing in workplace law. Yes, you read that right. An employment attorney who advises clients on harassment cases, discrimination claims, and workplace rights. And yes, I was sexually harassed at work, paid to stay silent, and trapped by an NDA for years. The irony wasn't lost on me. It haunted me every single day. I started working at Tech Venture Solutions in January 2018. It was a mid-sized tech company based in San Diego, about 800 employees, growing fast, good reputation in the industry. I was hired as senior legal counsel reporting to the general counsel. My job was to handle employment law issues, reviewing policies, advising on terminations, ensuring compliance with labor regulations. I loved the work, the team was smart, the company was doing interesting things, and I felt like I was making an impact. David Chen was the vice president of sales. He'd been with the company for 12 years, was well connected, brought in major clients. He was seen as untouchable, one of those executives who could do no wrong because he made the company so much money. I met him my second week. He came to legal because his team was hiring aggressively, and he wanted to make sure the offer letters were compliant. He was charming, friendly, made jokes, asked about my background, welcomed me to the company. The first inappropriate comment came about a month later. I was in the break room getting coffee. David walked in, looked me up and down, and said, "That dress looks great on you. You should wear it more often." It wasn't overtly sexual, but the way he said it, the way he looked at me, it felt wrong. I'm an employment attorney. I know what workplace harassment looks like. I know the difference between a genuine compliment and something that crosses a line. This crossed the line, but I was new. He was a VP, and it was just one comment, so I smiled politely and left. The comments continued over the next few months, always when we were alone or in small groups where he felt comfortable. "You have beautiful eyes. I love your hair like that."
You should come to the sales team happy hour. I'd love to get to know you better outside of work.
Each comment individually could be dismissed as friendly, but together they formed a pattern. And I knew, because this is literally my area of expertise, that a pattern of comments focusing on appearance and personal interest can constitute harassment, even if no single comment is overtly sexual. I started avoiding him, took the stairs instead of the elevator if I saw him, skipped company events where I knew he'd be. But we worked at the same company, we had meetings together. I couldn't avoid him completely. In October 2018, about 9 months after I started, it escalated. There was a company dinner celebrating a major contract David's team had closed. The whole executive team was there, plus senior staff from various departments, including me. David sat next to me at dinner, spent the entire meal leaning close, touching my arm when he talked, making comments about how glad he was I was there. After dinner, people moved to the bar. David followed me, stood too close, put his hand on my lower back. I stepped away, he followed. "Why are you always avoiding me?" he said. "I think we'd be good together." "I'm not interested," I said clearly, "and this is inappropriate workplace behavior." He laughed. "Come on, Maya, don't be so uptight. I'm just being friendly." I left immediately, went home shaking, furious. I'm an employment attorney. I counsel people through situations exactly like this. I tell them document everything, report immediately, don't wait. And here I was, 9 months into a job I loved, being harassed by a VP, and I had reported nothing. The next day, I started documenting every comment I could remember with dates and contexts. Every time he had made me uncomfortable. I had about 30 incidents documented over 9 months. I knew I needed to report to HR, but I also knew how these things usually went. David was a VP who brought in millions in revenue. I was a new senior counsel who could be replaced. The company would protect him, not me. But I also knew that if I didn't report, it would continue, and I'd be complicit in allowing a harasser to keep harassing. So in November 2018, I filed a formal harassment complaint with HR. I met with the HR director, Lisa, gave her my documentation, explained the pattern of behavior, made clear that David had created a hostile work environment and that his conduct violated company policy. Lisa took notes, told me she took my complaint seriously, said they would investigate. 2 weeks later, I was called to a meeting with Lisa and the general counsel, my direct boss. They said they had investigated my complaint. They had interviewed David. He denied any inappropriate behavior and said he had only been friendly and welcoming to a new colleague. They had also interviewed 2 other people who had been at the company dinner. Both said they hadn't witnessed any inappropriate behavior. We couldn't find evidence to substantiate your claims, Lisa said, but we take all complaints seriously. We've reminded David about appropriate workplace conduct and professional boundaries. That was it. A reminder. No consequences. No changes to reporting structure. No acknowledgement that his behavior had been wrong. What about my documentation? I said. I provided 30 documented incidents over 9 months. Your perspective is important, the general counsel said carefully, but without corroborating witnesses, it's difficult to take action based on one person's account, especially when the other party denies the behavior. I knew what this meant. They didn't believe me, or they did believe me, but didn't want to act because David was too valuable. I want it on record, I said, that I believe the company is not taking this complaint seriously and that I'm concerned about retaliation. Of course, Lisa said, there will be no retaliation. We have a strict non-retaliation policy. The meeting ended. I went back to my office feeling sick. I'm an employment attorney. I know exactly what just happened. They had conducted a sham investigation designed to protect the company from liability while doing nothing to address the actual problem. And I knew what would happen next. The harassment would continue. And if I complained again, they'd say I was being difficult or oversensitive. I started looking for other jobs immediately, but then the retaliation started. Subtle at first. I was left off email chains I should have been included on. Meetings were scheduled without inviting me. Projects I had been working on were reassigned to other attorneys. My boss, the general counsel, started criticizing my work. Things that had been fine before were suddenly problems. In January 2019, my annual review was due. I had been there 1 year. My boss gave me a rating of needs improvement, said I wasn't collaborating well with other departments, said there were concerns about my judgment on several matters. None of it was true, and I knew exactly what was happening. This was textbook retaliation for filing a harassment complaint. I documented everything, saved emails, kept copies of my work product that showed the quality of my work, built a case proving retaliation. But I was also exhausted. Going to work every day was draining. I was stressed, anxious, barely sleeping. And David, the person who had harassed me, was still there, still thriving, still being treated like a star executive. He stayed away from me physically after my complaint, but I'd see him in meetings, at company events, walking past my office, every time I felt sick. And I started noticing something else. There were other women in the company who seemed uncomfortable around David, women who would leave rooms when he entered, women who seemed to avoid being alone with him. I wondered, had he done this to them too? How many of us were there? But I couldn't ask, because they might report me for trying to organize some kind of action against him, and that could be used to justify firing me. So I stayed silent and looked for other jobs and tried to survive each day. In April 2019, I got an interview at another company. Different industry, similar role. The interview went well, but when they called my references, they spoke to my current boss, the general counsel at Tech Venture. I didn't get the job. I suspected my boss had given me a bad reference in retaliation for the harassment complaint, but I couldn't prove it. I was trapped. I couldn't leave because I couldn't get a good reference, but staying was destroying my mental health. In July 2019, David cornered me in a conference room after a meeting. Everyone else had left. I was gathering my things. He closed the door. I know you're trying to damage my reputation, he said. It's not going to work. I've been here 12 years. The company values me. You're replaceable. My heart was pounding. We were alone in a room. He was blocking the door. I need you to leave, I said, trying to keep my voice steady. I'm just trying to give you some advice, he said. Drop the victim act. It's not a good look for someone in legal. Makes you seem emotional, unstable. Then he left. I sat in that conference room for 20 minutes trying to stop shaking. That night, I updated my documentation, added the conference room confrontation, noted that it was clearly retaliatory. I also started seeing a therapist. The stress was affecting everything: my sleep, my health, my relationships. My therapist asked, "Why don't you file a complaint with the EEOC or sue them?" I'm an employment attorney. I know my rights. I know exactly what claims I could bring: harassment, retaliation, hostile work environment. But I also know that employment litigation is brutal. It takes years. It costs thousands in legal fees. And even if you win, your career is damaged because you're marked as someone who sued their employer. I wasn't ready for that battle. So I stayed and documented and survived. In September 2020, David was promoted to Senior Vice President of Sales. Got a bigger office, bigger salary, more power. I was still at the same level, still being subtly marginalized, still coming to work every day feeling sick. Then COVID hit, the company went remote, and suddenly I didn't have to see David in person anymore. It was a relief. I could do my job from home without the constant stress of potentially running into him. But the retaliation continued, just in different forms: being left off important Zoom calls, having my recommendations ignored. In March 2021, almost exactly 3 years after I'd started, I was called to a meeting with HR. Lisa, the HR director, was there. So was an outside attorney the company had hired. They told me the company had decided to eliminate my position as part of a restructuring. I would be offered a severance package: 6 months' salary, about $95,000, in exchange for signing a separation agreement that included a confidentiality clause and a release of all claims. I knew immediately what this was. They were paying me to go away quietly. The outside attorney walked me through the separation agreement. It was 15 pages of dense legal language. But the key provisions were clear. I would agree never to discuss my employment at the company, never to disparage the company or any employee, and never to file any legal claims related to my employment. In exchange, I'd get $95,000. You have 21 days to review this, the attorney said. We encourage you to consult with your own lawyer. The meeting ended. I went home, or rather, I stayed home since I was already working remotely, and read the agreement carefully. It was a comprehensive gag order. If I signed, I could never talk about what David had done, never warn other women, never speak up if I saw him doing it again at industry events. And the release of claims meant I couldn't sue them for the harassment, the retaliation, the hostile work environment. I spent 2 weeks agonizing over the decision. Part of me wanted to reject it, wanted to file an EEOC complaint, sue them, expose everything. But the practical part of me, the employment attorney who knew how these cases actually went, understood the reality: employment litigation is expensive, time-consuming, and emotionally draining. Most cases settle anyway, and even when plaintiffs win, the wins are often hollow. Some money, but no real accountability, no systemic change. And I was exhausted. 3 years of harassment, retaliation, stress. I wanted it to be over. So I told myself, take the money, move on, find a better job, put this behind you. I also told myself, this is a business decision. They're paying me to avoid litigation. That's leverage. That's success in a way. But deep down, I knew the truth. I was letting them buy my silence. And David would continue working there, probably harassing other women, protected by the company and NDAs like mine. I signed the agreement in April 2021. $95,000 hit my bank account. I officially resigned, started telling people I had left to pursue other opportunities, and that was it. 3 years of harassment and retaliation ended with a check and a gag order. I found a new job pretty quickly, joined a smaller firm specializing in employment law, went back to counseling clients on harassment and discrimination cases. The irony was almost unbearable. I was advising people how to handle situations I hadn't been able to handle myself. But I was bound by the NDA. I couldn't talk about what had happened at Tech Venture. Couldn't use my own experience as an example. Couldn't warn others. Life moved on. I tried to put it behind me, but I couldn't escape it completely because David Chen was still a prominent figure in San Diego's tech scene. I'd see his name in industry publications, see him speaking at conferences, see him honored with awards. And every time I'd wonder, is he still doing it? How many more women has he harassed since I left? In 2023, I ran into him at a tech industry mixer. He was there with tech venture colleagues, networking, laughing, being treated like the successful executive he was. He saw me, smiled, nodded like we were old friendly colleagues. I left immediately, went home and cried. My therapist asked me, "Why is this still affecting you so much?" I said, "Because I'm an employment attorney. I help people stand up to harassers, but I didn't stand up. I took the money and signed the NDA. I enabled him to keep harassing people." "You did what you needed to do to protect yourself," she said. "That's not enabling, that's surviving." But it didn't feel like surviving. It felt like failing. I thought about the NDA constantly, wondered if there was any way to get out of it. But I knew the answer. NDAs and employment settlements are generally enforceable. If I violated it, the company could sue me for breach of contract, demand the money back, seek damages. I was trapped by my own signature. Then, in October 2025, I saw a news story that changed everything. California was considering a new law, Assembly Bill 250, that would temporarily lift the statute of limitations for adult survivors of workplace-related sexual harassment cover-ups. The bill was specifically designed to address situations like mine, cases where harassment had been covered up by settlements and NDAs, cases where victims had been silenced. The bill would create a 2-year window from January 1st, 2026 through December 31st, 2027, during which survivors could file civil lawsuits regardless of when the harassment occurred and regardless of any settlement agreements or NDAs they had signed. I read the bill text immediately, read it over and over. This was it. This was the way out. If AB 250 passed, my NDA wouldn't matter anymore. The release of claims I had signed wouldn't matter. I could sue Tech Venture and David Chen for what they had done. I followed the bill closely through the California legislature, watched as it passed the Assembly, passed the Senate, went to the governor's desk. On December 20th, 2025, Governor Newsom signed AB 250 into law. It would take effect January 1st, 2026. I had less than 2 weeks to wait. On January 1st, I reread the law, made sure I understood every provision. It was clear. Survivors of workplace sexual harassment cover-ups could now file civil claims even if they had signed NDAs or releases. The window was open. I called an attorney I knew who specialized in plaintiff-side employment litigation. "I have a case," I said. "Harassment. Retaliation. Cover-up with NDA. I want to sue under AB 250. We met 2 days later. I brought all my documentation. 3 years of notes, emails, contemporaneous records. She reviewed everything, asked detailed questions, made sure I understood what filing a lawsuit would mean. "This will be public," she said. "Your name will be on court documents. The company will fight back. They'll try to paint you as a disgruntled former employee. It will be difficult." "I know," I said. "I'm an employment attorney. I know exactly what they'll do." "And you still want to proceed?" "Yes, We filed the lawsuit on January 15th, 2026. Named both Tech Venture Solutions and David Chen as defendants. Alleged sexual harassment, retaliation, hostile work environment, and cover-up through coercive NDA. The complaint was specific, detailed, included dates, incidents, documentation, and most importantly, it was public. Within hours of filing, the case started getting attention. A local reporter covering employment law saw the filing and wrote a story. "Employment attorney files harassment lawsuit under new AB 250 law." The article included my name, David's name, and Tech Venture's name, included allegations from the complaint. It was online by evening, and that's when my phone started ringing. The first call came at 7 p.m. the night the story was published. Unknown number. I almost didn't answer, but something told me to pick up. "Is this Maya Patel?" a woman's voice said. "Yes. I saw the article about your lawsuit against David Chen and Tech Venture." My heart started racing. "Yes, I filed it this week." There was a pause. "Then he did it to me too."
I sat down. What's your name?
Sarah. I worked at Tech Venture from 2014 to 2017. I was in marketing. David harassed me for 2 years. When I complained to HR, they paid me $80,000 to sign an NDA and leave. I thought I could never talk about it. You can now, I said, AB 250. The law that let me file my lawsuit, it applies to you too. I know, she said. That's why I'm calling. I want to sue them. Can you give me your attorney's number? I gave her my attorney's contact information. We talked for another hour. She told me her story so similar to mine, it was eerie. The pattern of comments, the escalation, the sham HR investigation, the retaliation, the buyout. After we hung up, I sat there processing. I wasn't the only one. David had done this before. The second call came an hour later. Another woman, Amy. She had worked at Tech Venture from 2008 to 2011. Same pattern, same NDA. Then a third call, Jessica, 2019 to 2021, overlapping with my time there. We had both been there at the same time, both being harassed by David, both too scared to talk to each other because of the power dynamics and fear of retaliation. By the end of the first week after my lawsuit became public, 8 women had contacted my attorney. 8 women, all harassed by David Chen, all bought off with NDAs, all silenced for years. The cases dated back to 1998, 26 years. David had been harassing women at Tech Venture for 26 years, and the company had been covering it up the entire time. My attorney filed a motion to consolidate the cases. We would proceed as a group, not technically a class action, but coordinated litigation with multiple plaintiffs against the same defendants. Tech Venture and David's legal team tried to fight it. They argued that the AB 250 law couldn't apply to settlements that had been signed years ago, that it violated the sanctity of contract law. But the judge disagreed. She ruled that AB 250 explicitly allowed survivors to come forward despite prior NDAs, and that public policy favoring the exposure of harassment cover-ups outweighed contract enforcement. The cases would proceed. That ruling opened the floodgates. More women came forward, women who had left Tech Venture years ago and thought they'd never be able to speak, women who had been carrying the secret and the shame for decades. By March, we had 14 plaintiffs. By April, 18. 18 women spanning 26 years. The oldest was now 62 years old. She had been harassed by David when she was 36, paid off with $30,000, and had never told anyone, not even her husband. The youngest was 29. She had been a junior marketing coordinator. David had harassed her for 6 months before HR paid her $50,000 and she left. As the plaintiffs organized, we started sharing our experiences. We met in person, all 18 of us, plus our attorneys, in a conference room in downtown San Diego. We went around the table. Each woman told her story, and the patterns were chilling. David used the same tactics with almost all of us. Started with comments about appearance, escalated to physical touching, hands on lower back, shoulders, arms, then explicit propositions. When we complained to HR, the company followed the same playbook every time. Sham investigation. No corroboration found. Reminder to David about professional conduct. Then retaliation against the complainant until they were willing to take money and leave. The amounts varied from $30,000 in the late 90s to $120,000 in recent years, but the pattern was identical. Tech Venture had spent $2.8 million over 26 years paying women to stay silent about one executive's harassment. They had calculated correctly that it was cheaper to pay settlements than to fire David or face public litigation. Until AB 250 changed the rules. Our legal team requested discovery from Tech Venture. We wanted all HR files related to David Chen, all complaints, all investigation records, all settlement agreements. The company fought the discovery requests hard. They claimed the documents were privileged, confidential, protected by attorney-client privilege, but the judge ordered them to produce the documents. And what we found was damning. There were 23 complaints about David Chen in company files spanning from 1997 to 2024. 23. 18 of those complaints had resulted in settlement agreements with NDAs. The women who filed those complaints were the 18 plaintiffs in our lawsuit. But there were 5 other complaints from women who complained but didn't take settlements. Some had just quit without pursuing it further. Some had been fired shortly after complaining. We tried to locate those 5 women to see if they wanted to join the lawsuit. We found 3 of them. One agreed to join as a plaintiff. The other 2 said they couldn't. The experience had been too traumatic. They had moved on with their lives. They couldn't go through it again. I understood. Not everyone was in a position to fight, but we also found something else in the discovery documents, something that made the case even stronger. There were internal emails from tech venture executives and HR leadership discussing David's behavior. A 2012 email from the HR director to the CEO. David Chen has generated another complaint. 3rd one in 5 years. At what point do we consider that the pattern indicates a real problem rather than isolated personality conflicts? The CEO's response: David brings in $20 million a year in revenue. Unless we have a complaint that's going to result in a lawsuit we can't win, we manage it through settlements. It's a cost of doing business. A cost of doing business. That phrase appeared in multiple emails. Tech venture executives literally referred to harassment settlements as a routine business expense. A 2019 email from the general counsel, my former boss, to HR. We have another David Chen situation. Complainant is an attorney in my department, which makes this more sensitive. Recommend we document any performance issues to justify termination if she doesn't accept a settlement. That email was dated 2 weeks after I filed my harassment complaint. It was proof that the retaliation against me had been deliberate and planned at the executive level. We also found financial records showing exactly how much Tech Venture had paid in settlements, $2.8 million over 26 years. And we found David's personnel file. It showed he had received performance bonuses every single year, including years when multiple harassment complaints had been filed against him. His compensation had increased from $300,000 in 2000 to over $1 million by 2025. The company had been rewarding him while paying off his victims. When the discovery documents were filed with the court becoming public record, the media coverage intensified. The San Diego Union Tribune ran a front-page story. Tech companies spent $2.8 million covering up executives' harassment over 26 years. The story included details from the internal emails, the cost of doing business quote, the deliberate retaliation against complainants. It went viral. National outlets picked it up. The New York Times, Washington Post, NPR, they all covered it as an example of how companies systematically protected harassers and silenced victims. Tech Venture's CEO issued a public statement. We take all complaints of harassment seriously and have robust policies to address misconduct. We strongly dispute the allegations in this lawsuit and will defend ourselves vigorously. But the internal emails told a different story, and everyone could see them. The company's stock price dropped 15% in 2 days. Several major clients announced they were reviewing their relationships with Tech Venture. Employees started quitting. The board of directors called an emergency meeting. 3 days after the discovery documents became public, Tech Venture announced that David Chen had been terminated effective immediately. 26 years, 23 complaints, 18 settlement agreements, $2.8 million in hush money, and he was finally fired. But only because the secret was out. Only because AB 250 had allowed us to speak. Only because 18 women had decided to fight together instead of suffering in silence. David hired his own attorney and issued a statement. The allegations against me are false and defamatory. I have always conducted myself professionally and appropriately. I intend to clear my name. But we had the emails, the HR files, the documented complaints, 18 witnesses who would testify under oath to consistent patterns of behavior.
His denials rang hollow.
The company tried one more strategy. They offered to settle. In May, their attorney contacted our legal team. They proposed a global settlement. Tech Venture would pay each plaintiff an amount based on the severity and duration of the harassment they experienced. Total settlement fund, $7.5 million. In exchange, we would dismiss all claims against the company and against David Chen personally. Our legal team brought the offer to all 18 plaintiffs. We met again in the conference room. The discussion was intense. Some women wanted to take the settlement. They were exhausted by the litigation, wanted closure, needed the money. Others wanted to keep fighting, wanted a trial, wanted to force the company to publicly admit wrongdoing in a courtroom rather than settling quietly. I understood both perspectives. I had taken a settlement once before. It was why I was in this situation. I knew the appeal of getting money and moving on. But I also knew that settlements, even large ones, rarely led to real accountability or systemic change. We talked for hours. Finally, we took a vote. 15 of the 18 plaintiffs voted to accept the settlement if we could negotiate better terms. 3 wanted to proceed to trial no matter what. Our attorneys went back to Tech Venture with our position. We wanted a larger settlement fund, $10 million, not 7.5, a public admission from Tech Venture that they had failed to adequately address David Chen's harassment and that they had retaliated against complainants. Mandatory policy changes, annual harassment training for all executives, independent third-party investigations of all harassment complaints, prohibition on settlement agreements with NDAs and harassment cases. David Chen personally had to pay $2 million from his own assets into the settlement fund. Tech Venture balked at the public admission and the policy changes, but we wouldn't budge. The negotiations dragged on for 6 weeks. Finally, in late June, we reached an agreement. $10 million settlement fund divided among the 18 plaintiffs. Amounts range from $300,000 to $800,000 depending on severity and duration of harassment. Public statement from Tech Venture acknowledging that they had failed to adequately respond to complaints of harassment and that they deeply regret the harm caused to the plaintiffs.
Mandatory policy changes implemented and audited by an independent firm for 5 years.
David Chen personally contributed $1.2 million to the settlement fund. And crucially, the settlement agreement did not include an NDA. We could talk about what happened. We could tell our stories. That last provision was the one I cared about most. The whole problem had been silence. If we settled and were silenced again, we'd just be perpetuating the cycle. But this settlement explicitly allowed us to speak. We accepted the terms. The settlement was finalized in July 2026. When the settlement was announced, it made headlines again. $10 million, public admission, no NDA. It was one of the largest harassment settlements in California history, and it was a direct result of AB 250 enabling survivors to come forward despite prior confidentiality agreements. But the story didn't end with the settlement, because David Chen still faced consequences beyond just money. In August, the California Attorney General's office announced they were opening a criminal investigation into potential fraud and conspiracy charges related to the cover-up of harassment complaints. The investigation focused on whether Tech Venture executives had engaged in criminal conduct by deliberately retaliating against complainants and creating false performance documentation to justify terminations. The internal emails we had obtained in discovery became evidence in the criminal investigation. In October, criminal charges were filed against David Chen, multiple counts of criminal harassment under California law, which had been strengthened in recent years to include persistent workplace harassment as a misdemeanor. Charges were also filed against Tech Venture's former CEO and former general counsel for conspiracy to obstruct justice by covering up the harassment through fraudulent means. The criminal cases were still pending as of the end of 2026, but the fact that they were filed at all was significant. For so long, harassment had been treated as a civil matter. You sue, you get money, that's it. But these criminal charges sent a message. This behavior wasn't just a workplace issue, it was criminal conduct. The impact extended beyond just our case and Tech Venture. AB 250 had created a 2-year window for survivors to come forward, and dozens of other women across California started filing lawsuits under the law. By the end of 2026, over 100 AB 250 lawsuits had been filed across the state, cases involving major companies, small businesses, nonprofits, all following the same pattern: harassment, cover-up, NDA, silence, until AB 250 broke the silence. The law became a model for other states. By early 2027, 5 other states had passed similar laws, creating windows for survivors of workplace harassment cover-ups to come forward. There was talk of federal legislation doing the same thing nationally. The conversation about NDAs and harassment cases was changing. Companies were starting to realize that forcing victims to sign NDAs created liability down the line rather than eliminating it. Several major corporations announced they would no longer use NDAs in harassment settlements, not because they were required to, but because the risk of future exposure under laws like AB 250 made NDAs ineffective as protection. For me personally, the settlement money was life-changing. I received $680,000, one of the higher amounts because I had experienced both harassment and extensive retaliation. But more important than the money was the freedom to talk. I started speaking publicly about what had happened, gave interviews to media outlets, spoke at conferences about workplace harassment and the importance of laws like AB 250. I also started working with advocacy organizations to support other survivors and help them understand their rights, connected them with attorneys, provided resources for emotional support. And I started a project called Breaking NDAs, a database and support network for survivors of workplace harassment who had been silenced by confidentiality agreements. The project provided legal information about laws like AB 250, connected survivors with attorneys, and created a community where people could share their stories anonymously if they weren't ready to go public. Within 6 months, Breaking NDAs had over 5,000 registered users. Stories from tech, finance, entertainment, healthcare, education. Every industry had the same problem. The response showed me that our case, the 18 of us who sued Tech Venture, wasn't unusual. It was the tip of an enormous iceberg. How many harassers were still protected by NDAs? How many victims were still silenced? How many companies were still treating settlements as a cost of doing business? AB 250 was a tool, but it was only available for 2 years, and it only applied in California. Real change would require federal legislation. It would require companies to fundamentally rethink how they handled harassment complaints. It would require holding executives personally accountable, not just with money, but with criminal consequences. But progress was happening slowly, incompletely, but happening. And it was happening because survivors were speaking up, because laws like AB 250 were giving them the power to break NDAs that had silenced them for years or decades. I thought a lot about the irony of my own situation. I'm an employment attorney. I had spent years counseling clients on harassment cases, telling them to document everything, report immediately, fight back. But when it happened to me, I had taken the money and signed the NDA. I had done exactly what I told clients not to do. For years, I had felt like a hypocrite, like I had failed. But I came to understand that survival isn't failure. Taking a settlement when you're exhausted and traumatized and just need it to be over, that's not weakness. That's self-preservation. The failure wasn't mine. It was the system that forced that choice. The system that made settlements the only viable option for most people because litigation was too expensive, too slow, too risky. AB 250 didn't fix that system entirely, but it created a crack in the wall, a way for survivors to come back later when they were ready and fight for accountability. And that mattered. In November 2026, I was invited to speak at a conference on workplace harassment law. The audience was mostly employment attorneys, HR professionals, company executives. I told my story, the harassment, the sham investigation, the retaliation, the NDA, the years of silence, then AB 250 and the lawsuit, and the 18 women who came forward. At the end, someone asked, "What do you want people to take away from your experience?" I thought about it for a moment. Then I said, NDAs don't make harassment go away. They just hide it. And eventually the truth comes out. Companies that think they can buy silence are wrong. They're just buying time. And when the truth finally emerges, the cost is so much higher than if they had just dealt with the problem honestly in the first place. The other thing I want people to understand is that survivors shouldn't have to choose between their financial security and their right to speak. NDAs force that choice. They force you to weigh money against truth. That's not a choice anyone should have to make. Laws like AB 250 help, but the real solution is for companies to stop using harassment settlements as a business strategy, stop protecting harassers because they make you money, stop treating victims as problems to be managed rather than people who deserve justice.
The room was silent.
Then someone started clapping. Then more people. Then the whole room was applauding. I don't know if I changed any minds that day. I don't know if any of those executives went back to their companies and reformed their practices, but I hope some of them did. Because the alternative, the world where companies keep protecting harassers and silencing victims, is a world where people like David Chen operate with impunity for 26 years, and that world needs to end. As 2026 came to a close, I found myself reflecting on how much had changed in just 1 year. January 1st, AB 250 had gone into effect. I had filed my lawsuit 2 weeks later. By February, other women were coming forward. By summer, we had a settlement. By fall, criminal charges were filed. One law, one 2-year window, and it had broken open 26 years of silence. But I also thought about what hadn't changed. David Chen was out of tech venture, but he wasn't in prison. The criminal charges were still pending, and even if convicted, criminal harassment was a misdemeanor. He might face fines, probation, community service, but not prison time. He had lost his job and his reputation. He had paid $1.2 million, but he had also made millions in salary and bonuses over his 26-year career. He wasn't destitute. He wasn't destroyed. And I wondered, was that justice? Was it enough? Some of the other plaintiffs felt the settlement was adequate. They had gotten money, gotten closure, gotten to tell their stories. That was enough for them. Others felt like I did. That real accountability meant more than money. It meant consequences that actually deterred future harassers. It meant systemic change that protected future victims. I didn't have an answer. Justice is complicated. Different people need different things to heal. But I knew this. We had achieved more than I thought possible when I first signed that NDA in 2021. Back then, I thought I would never be able to speak about what happened. Thought David would continue harassing with impunity. Thought Tech Venture would keep covering it up. AB 250 changed all of that, and the ripple effects extended far beyond our case. In December 2026, I was contacted by a state legislator from New York. She was drafting legislation similar to AB 250 for New York State and wanted to consult with survivors who had used the California law. I spent 2 hours on the phone with her, explaining how the law worked, what challenges we'd faced, what provisions had been most important. The New York bill was introduced in January 2027. It passed both houses of the legislature by March and was signed into law in April. Similar bills were pending in Illinois, Massachusetts, Washington, and Oregon. The model was spreading, and it wasn't just legislation. The cultural conversation about harassment and NDAs was shifting. Major law firms that represented employers started advising clients to stop using NDAs and harassment settlements. Not because it was required by law in most states, but because the risk of future exposure made them ineffective. Several prominent companies announced voluntary policies prohibiting NDAs and harassment cases. Microsoft, Google, Facebook, Amazon all said they would no longer require confidentiality in harassment settlements. Some of that was genuine reform, some of it was public relations, but either way, it was progress. The fact that major corporations felt pressure to change their policies showed that the issue had reached mainstream awareness. People understood now that NDAs weren't protecting victims, they were protecting harassers. My work with breaking NDAs continued to grow. By early 2027, we had over 10,000 registered users. We had expanded beyond just legal resources. We offered therapy referrals, career counseling, financial planning assistance, all the things survivors needed to rebuild their lives after leaving toxic workplaces. We also started a legal fund to help survivors who couldn't afford attorneys. Employment litigation is expensive, and not everyone could self-fund a lawsuit or find an attorney willing to take their case on contingency. The fund provided grants for legal fees, expert witnesses, court costs. In its first 6 months, we helped 40 survivors file harassment lawsuits who otherwise wouldn't have been able to afford it. Many of those cases were AB 250 cases. Survivors coming forward during the 2-year window to sue employers who had silenced them years earlier. But some were current cases, people who were being harassed now, who were reporting it now, who were fighting back now. And that was encouraging because it meant that the culture was changing, people were less willing to stay silent, more willing to fight. I also started teaching. A local law school asked me to give a guest lecture on workplace harassment law. I agreed. Standing in front of a classroom of law students, most of them in their 20s, preparing for careers in law, I told them my story. I told them about being harassed despite being an employment attorney, about the sham HR investigation, about the retaliation, about taking the settlement and feeling like I'd failed. And I told them about AB 250, about coming forward 5 years later, about the 18 women, about the $10 million settlement, and the criminal charges, and the policy changes. Then I told them, some of you will go into corporate law and represent companies. When you're advising a client on how to handle a harassment complaint, remember this. The right thing to do is almost always the legally safest thing to do in the long run. Fire the harasser. Support the victim. Don't cover it up, because cover-ups don't stay covered up forever. And some of you will represent plaintiff survivors like me. When you do that work, remember that your client is dealing with trauma, not just a legal problem. Be patient, be compassionate, and fight like hell for them. After the lecture, several students came up to me. One young woman said, "I was harassed during a summer internship last year. I didn't report it because I was afraid it would hurt my career. Hearing your story makes me think maybe I should." "You should," I said. "And if you need help, contact Breaking NDAs. We'll connect you with resources." She thanked me. I watched her leave and hoped she would follow through, because that's how change happens. One person at a time, one story at a time, one survivor finding the courage to speak. In February 2027, I received an email that caught me completely off guard. It was from a woman named Patricia. She said she had worked at Tech Venture from 1996 to 1998. She said David Chen had harassed her. When she complained to HR, they offered her $30,000 to resign and sign an NDA. She took it, left, never spoke about it, until she saw the news stories about our lawsuit. Then she realized she had been the first. David's pattern of harassment had started with her. If the company had fired him then, in 1998, the 17 women who came after her, including me, wouldn't have been harassed. Patricia wrote, "I've carried guilt for 29 years. I thought if I had fought harder, if I hadn't taken the money, maybe I could have stopped him. I know intellectually it's not my fault, but the guilt is still there." I called her immediately. "It's not your fault," I said. "You did what you needed to do to survive. The fault is with David for harassing you, and with Tech Venture for protecting him." "I know," she said, "but I still wonder. If I had sued back then." "If you had sued back then, you would have faced exactly what we faced. Except you would have been alone. No AB 250, no 18 other women to back you up. You would have been destroyed. You did the only reasonable thing." "Thank you," she said quietly. We talked for over an hour. I told her about breaking NDAs, about the community of survivors, about how she could still tell her story if she wanted to. The AB 250 window is still open until December 2027, I said. "You could still sue if you want to." "I'm 62 years old," she said. "I don't have the energy for a lawsuit, but I would like to tell my story, to add my voice to yours." "Then do it," I said. "We'll support you." Patricia wrote an op-ed for the San Diego Union Tribune. It was published in March 2027, titled, "I was David Chen's first victim. My silence enabled 29 years of harassment." In it, she told her story, the harassment, the settlement, the guilt. She ended with, "I don't blame myself anymore, but I do want other young women to know speaking up is hard, fighting is hard, but silence enables abusers. If there's a way to speak safely through laws like AB 250, through organizations like Breaking NDAs, through solidarity with other survivors, take it. Your voice matters more than you know." The op-ed went viral. Patricia was interviewed on local news. She joined Breaking NDAs as an advisor, and her story completed the picture. 29 years. 19 women we knew about, probably others who never came forward at all. One man, one company, decades of harm. All enabled by NDAs and settlements and a corporate culture that valued profit over people. That's what we were fighting against. Not just David Chen, not just Tech Venture, but the entire system that made cases like this possible. By spring 2027, I had become a full-time advocate. I left my law firm job and focused entirely on breaking NDAs, speaking engagements, and consulting work. I made less money than I had as an attorney, but the work was more meaningful. I was invited to speak at conferences, corporate events, universities. Each time I told some version of the same story, the harassment, the silence, the law that broke the silence, the 18 women who stood together. And each time, people came up to me afterward with their own stories, their own experiences with harassment, retaliation, NDAs, silence. I heard from people in tech, finance, healthcare, entertainment, retail, hospitality, education, nonprofits. Every industry had the same problems. I heard from women and men. Most survivors were women, but men also experienced harassment and were also silenced by NDAs. I heard from people in their 20s who had just entered the workforce, and from people in their 60s who had carried secrets for decades. The common thread was power imbalance. Harassers had power, usually through position, sometimes through connections, sometimes through revenue they generated. Victims lacked power, and companies protected power, not people. Breaking that dynamic required legal tools like AB 250, but it also required cultural change. It required believing victims, taking complaints seriously, investigating thoroughly and fairly, firing harassers regardless of how valuable they were to the company, refusing to use NDAs to cover up problems. Some companies were starting to make those changes. Not all, not even most, but some. And the ones that did make changes often cited our case as the wake-up call. They saw what happened to tech venture, the public humiliation, the financial cost, the criminal charges, and decided they didn't want the same fate. Fear was motivating some positive change. I would have preferred that companies did the right thing because it was right, not because they were afraid of consequences. But I'd take fear-driven reform over no reform at all. In May 2027, Breaking NDAs organized a conference, Beyond Silence, Survivors, Advocates, and the Future of Workplace Accountability. We held it in San Diego. Over 500 people attended: survivors, attorneys, activists, journalists, HR professionals, company executives who wanted to learn. I gave the opening keynote, told the story one more time, then introduced a panel of survivors who had used AB 250 to come forward. There were 18 of us from the tech venture case, but there were also survivors from other companies, other industries, other patterns of abuse. Each person told their story in 3 minutes or less. Just the essentials: what happened, how long they were silenced, what AB 250 had enabled them to do. By the time all the stories were told, there wasn't a dry eye in the room. Then we had a panel discussion: what comes after speaking up? Because that's the part that often gets left out. People think speaking up is the end. You tell your story, you get justice, you move on. But speaking up is just the beginning. After you break the silence, you have to deal with everything that comes next: the legal battle, the public scrutiny, the people who don't believe you or who blame you, the re-traumatization of having to relive the harassment in depositions and court filings. And then, if you win or settle, you have to figure out how to rebuild your life and career. One of the panelists, a woman named Jennifer, who had sued her former employer after being harassed by a supervisor, said it perfectly. I thought winning the lawsuit would bring closure. And it did bring some closure. But it also opened new questions. Who am I now? I defined myself for so long as someone who was wronged and silenced. Now I'm someone who spoke up and won. That's different. And I'm still figuring out what that means. I understood exactly what she meant. For 5 years, I had been Maya, the silenced victim, the employment attorney who couldn't even protect herself, the woman who took the money and signed the NDA. Now I was Maya, the advocate, the woman who broke the silence, the woman who helped 18 others find their voices. That was better, but it was also complicated, because I hadn't wanted to be defined by what David Chen did to me. I hadn't wanted harassment to become my identity, but it had my work, my speaking, my advocacy. It was all centered on that experience. Was that good? Was I making the most of a terrible situation? Or was I stuck in the past, unable to move forward? My therapist helped me work through those questions. You're not stuck, she said. You're choosing to use your experience to help others. That's not the same as being defined by trauma. That's transforming trauma into purpose. I held on to that thought: transformation, not definition. I was more than what had happened to me. But what had happened to me had shaped who I had become, and I could use that to make the world slightly better for other people. That was enough. In June 2027, the California Attorney General's office announced the results of the criminal investigation into tech venture. David Chen was convicted on 6 counts of criminal harassment. He was sentenced to 1 year in county jail, suspended, 3 years probation, 500 hours of community service, and mandatory counseling. He was also barred from holding any management position in California for 10 years. It wasn't prison time, but it was something: a criminal record. Restrictions on his career, public acknowledgement that what he did was criminal. The former CEO and general counsel both pled guilty to conspiracy charges in exchange for reduced sentences. They received probation, fines, and were barred from executive positions in California for 5 years. Again, not the harshest penalties, but not nothing. And the symbolism mattered. Executives could face criminal consequences for covering up harassment. That was precedent. Would it deter future cover-ups? Maybe. Maybe not. But it was better than the alternative, where executives face no consequences at all. When the sentencing was announced, the media asked me for comment. I said, this case shows that harassment isn't just a civil matter where you pay money and move on. It's criminal conduct, and covering it up is criminal conduct. Companies and executives need to understand that protecting harassers has real legal consequences, not just financial, but criminal. That soundbite made it into most of the news coverage. I hoped it made some executives nervous enough to think twice before writing another settlement check to cover up another harassment complaint. As summer turned to fall in 2027, I was invited to Washington, D.C. to testify before Congress again. The House Judiciary Committee was considering federal legislation similar to AB 250, a bill that would create a nationwide window for survivors of workplace harassment cover-ups to come forward despite NDAs. I testified alongside other survivors, employment attorneys, and advocates. I told the story for what felt like the 100th time of the harassment, the NDA, the silence, and AB 250 breaking that silence. Then I urged Congress to pass federal legislation. AB 250 worked in California, but survivors in other states don't have the same protection. We need a federal law that gives everyone the chance to come forward, that shows companies they can't hide behind NDAs forever, that tells survivors your story matters and the law will protect your right to tell it. The committee members asked questions. Some were supportive, some were skeptical, worried about undermining contract law, worried about frivolous lawsuits, worried about companies being unfairly targeted. I responded to each concern, emphasized that AB 250 cases required actual harassment, not just dissatisfaction with a settlement, noted that companies could avoid these lawsuits entirely by not covering up harassment in the first place. By the end of the hearing, I felt cautiously optimistic. Several committee members seemed genuinely interested in moving the legislation forward. Whether it would actually pass was another question. Congress moved slowly, and there was opposition from business groups who argued that lifting NDAs would create a litigation free-for-all. But the conversation was happening. That mattered. In October 2027, I received an unexpected email from TechVenture's new CEO. The company had replaced its entire executive leadership after the scandal. The new CEO was a woman named Dr. Rebecca Santos, who had been brought in specifically to rebuild the company's culture and reputation. Her email was brief. Ms. Patel, I'm reaching out to see if you would be willing to consult with TechVenture on reforming our harassment prevention and response policies. I understand if you're not interested given your history with the company, but I believe your expertise and perspective would be invaluable as we work to ensure nothing like what happened to you ever happens again. I stared at the email for a long time. Part of me wanted to delete it. TechVenture had enabled my harassment, retaliated against me, paid me to be silent. Why would I help them? But another part of me thought, this is a chance to actually change the culture at the company where all of this happened, to make sure the next person who complains is believed and supported, instead of silenced and pushed out. I called my therapist. We talked through it. What do you want? She asked. I want them to be better, I said. I want them to actually protect employees instead of protecting harassers. Then maybe this is an opportunity. I agreed to a meeting, met with Dr. Santos and her new head of HR. They asked me what TechVenture had done wrong, in my case. I told them everything, the sham investigation, the retaliation, the settlement designed to silence me. Then they asked, what should we have done instead?
Believe me, I said, take the complaint seriously from day one. Conduct a real investigation with independent investigators, not internal HR protecting the company. When you found a pattern, which you would have if you'd looked, fire David immediately. Support me instead of retaliating against me. Apologize. Make changes.
What changes? No more settlements with NDAs in harassment cases, mandatory reporting of all harassment complaints to the board of directors, independent investigations of any complaint involving executives, zero tolerance for retaliation, annual audits of harassment complaints to identify patterns. They took notes, asked follow-up questions, seemed genuinely interested. I agreed to consult with them for 6 months, help them draft new policies, trained their HR team and executives on how to respond to complaints, reviewed their processes for investigating and resolving harassment cases. It was strange being back in Tech Venture's offices, even though they'd moved to a new building after the scandal. Strange working with the company that had harmed me, but I was doing it on my terms now, as a consultant, not an employee, as someone who had fought them and won, not someone they had silenced. And I could see that they were actually trying to change. Not perfectly, not magically, but trying. Dr. Santos told me, we can't undo what happened, but we can make sure it doesn't happen again. That's what I'm committed to. I believed her. Whether Tech Venture would actually maintain those commitments long-term remained to be seen. Corporate memory is short, and cultures revert to old patterns when people stop paying attention. But for now, they were better than they had been. And that was progress. As November 2027 arrived, I realized the AB 250 window was almost closed. The law had created a 2-year period from January 2026 to December 2027 for survivors to come forward. That window would close in 6 weeks. Breaking NDAs launched a campaign, Final Call, Break Your Silence Before the Window Closes. We did outreach to survivors who had been silenced by NDAs but hadn't yet filed lawsuits, reminded them that time was running out, connected them with attorneys. In those final 6 weeks, over 200 new AB 250 lawsuits were filed across California. 200 more stories, 200 more survivors speaking up, 200 more companies being held accountable. The window closed on December 31st, 2027. In total, over 400 AB 250 lawsuits had been filed during the 2-year period. They involved companies in every industry, harassers at every level, patterns of abuse spanning decades. Not all of the cases resulted in settlements or convictions. Some were dismissed, some were still pending, but all of them represented survivors who had found their voices again after years or decades of silence. And the existence of the cases, the sheer number of them, proved that the problem was systemic. This wasn't a few bad apples. This was widespread corporate malfeasance. As 2028 began, I found myself thinking about what came next. AB 250's window had closed, but the momentum hadn't. Several other states had passed similar laws. Federal legislation was still pending in Congress. Corporate policies were changing, the culture was shifting. Not fast enough, not comprehensively enough, but shifting. I would keep doing the work, speaking, advocating, supporting survivors, pushing for systemic change. Because what happened to me and to the 18 other women, and to Patricia, and to the hundreds of others who came forward under AB 250 shouldn't keep happening. Harassment shouldn't be a routine cost of doing business. Victims shouldn't have to choose between financial security and the right to speak. Companies shouldn't be able to hide decades of abuse behind NDAs. And when someone finally does speak up, they shouldn't have to do it alone. That's what our case had proven. 18 women standing together were stronger than one woman silenced by an NDA. A community of survivors was stronger than a company trying to protect its reputation. Silence isolates. Speaking up connects, and connection is power. If you've been harassed at work, if you've been paid to stay silent, if you've carried a secret that wasn't yours to carry, know this: you're not alone. There are thousands of us, and more of us speak up every day. Laws like AB 250 give us tools, organizations like Breaking NDAs give us support, but ultimately change happens because individual people decide they're done being silent. I was silent for 5 years, bound by an NDA I thought would last forever, watching my harasser continue to thrive while I carried shame that wasn't mine. Then a law changed, and I spoke, and 17 others joined me, and together we brought down a 26-year pattern of abuse. If we can do it, you can too. Subscribe to The Quiet Reckoning for daily stories where victims become advocates, where silence breaks into solidarity, where one person speaking up gives 18 others the courage to do the same, and where companies learn that NDAs don't buy silence forever, they just buy time until someone finds the courage and the law to break free. New story every day. The Quiet Reckoning.